Whenever you're ready.
Thank you. We are absolutely delighted to be here today to do session 4 on AI generated evidence and the courts. I'm here with my esteemed colleague, the Honorable Paul W. Grimm, who is a retired district judge for the District of Maryland, and I'm Maura Grossman. I'm a professor in the School of Computer Science at the University of Waterloo and an adjunct professor of law at Osgoode Hall Law School and principal of Maura Grossman Law. So we have a very ambitious agenda for you today. We're going to start with the ways that AI-generated evidence might come to court. We're going to talk about evidentiary challenges related to what we refer to as acknowledged AI-generated evidence, and we'll define that. We're going to give you a primer on authenticity and admissibility, a quick tutorial on deepfakes. Then we'll talk about why unacknowledged AI-generated evidence presents unique challenges for the courts, in particular the impact of deepfakes on the trier of fact, some strategies for dealing with AI-generated evidence in court, a brief discussion of recent case developments involving AI. We'll go over the proposals for changes to the Federal Rules of Evidence concerning acknowledged and unacknowledged AI-generated evidence, and time permitting, we'll touch on some ethics issues. So let's start with the ways that AI-generated evidence might come to court. When Judge Grimm and I started writing about AI evidence in about 2019, we conceived of it as one thing. And Judge Grimm would say to me, make a statement to me, and I would say, well, that doesn't quite work in this situation. And then he'd make another statement and I'd say, well, that doesn't quite work in that situation. And after a while, we finally came to the realization we were really talking about two different things that required different analyses. And once we made this conceptual distinction, it became much easier to talk about each of these two things. So the first we referred to in a paper we wrote in the Columbia Science and Technology Law Review, which is in your materials, we referred to it as acknowledged AI-generated evidence. And that's evidence where everybody agrees that the evidence is the product of an AI system. And there, the key dispute involves whether the results or the system are valid, reliable, or contain any bias. We distinguish that from acknowledged AI-generated evidence, where the parties don't even agree whether the evidence is genuine in the first place. So one party says it's real, the other party says it's fake. And there, the key issue is the authenticity of the evidence. And we found if you could separate the AI into these two categories, it was much easier to talk about them. So let me give you a hypothetical. Plaintiff George Jetson has filed a complaint in the District of Maryland alleging his employer Spacely Space Sprockets has wrongfully terminated him due to his age of 71. He asserts age discrimination claims against Spacely, and he's seeking several $100,000 in damages and legal fees. Spacely answers, denying that age had anything to do with why Mr. Jetson was terminated. Instead, they set forth two particular reasons. One, they had used an HR vendor's proprietary AI tool program called UpperOut, and Mr. Jetson turned out to be a dud. He's in the lowest bottom quarter of all Spacely employees in terms of efficiency and effectiveness. Second, it has an audio recording of him having a conversation with its chief competitor CEO, Cogswell Cogs's CEO, Mr. Cogswell, about Spacely's trade secrets. So now this matter is before the court. So hypothetical issue number one is that Mr. Jetson asserts that the use of UpperOut software was completely improper and that it's merely a pretext to fire him. The conclusion of the tool that he's a dud, that he's in the bottom quartile, is wrong. This test wasn't used on people his age. It was tested on 30-year-olds, and therefore it doesn't take into account changes in cognition, et cetera, that take place as you get a little bit older. There's no science supporting this AI program. It shouldn't have been relied on by Spacely, and it shouldn't be admitted by the court. And Mr. Jetson sought information concerning the validity and reliability of the Upper Out program in discovery, and was told it's proprietary and Spacely can't give any information. That's your classic acknowledged AI-generated evidence problem. The other problem that comes up is Mr. Jetson says the audio recording of him is a deep fake. It's not him at all. He's never spoken to Mr. Cogswell. He doesn't know who Cogswell is. And somebody must have made this recording up. And he argues the recording is not admissible. Spacely disagrees, of course. And Mr. Jetson has asked and gotten a copy of the recording, but he wants the actual device on which it was recorded so he can check the metadata and for signs of fake creation. And Spacely either doesn't have it or won't give it to him. And that's your classic unacknowledged AI-generated evidence problem. So let's talk about the challenges related to acknowledged AI-generated evidence first, because Judge Grimm and I believe these are actually less complicated. We've dealt with scientific and technical information before, and in many ways, this is no different. So when we talk about scientific and technical information, often the first question we ask is, are the results accurate? We don't love the word accurate because accurate is an ambiguous word with multiple meanings. And as Judge Grimm points out, a broken watch is accurate twice a day. So we avoid using that word, and we like to use the words that are used in science, which are validity and reliability. Validity meaning, does the AI measure what it's supposed to measure or predict? And reliability meaning, does it measure or predict consistently in substantially similar circumstances? So if we want to measure my height and we bring in a scale, that's not a valid measure of my height. It may be a perfectly good scale, but it's not going to measure my height. If I step on the scale and the first time it says about 104 pounds, and then the second time it says 182 pounds, and the third time it says 64 pounds, that may be a perfectly valid scale, but it's not a reliable scale because it's not measuring my weight consistently. And it's really important when we talk about AI systems and the results of those systems that we distinguish between validity and reliability. When we get the accuracy first, one problem is it's a summary measure. It doesn't tell us anything about the kinds of errors that the system makes, and we'll talk a little bit more about that in a minute. And evidence can be accurate but still be biased. And unfortunately, when the US rules of evidence and the case law talk about these issues, they tend to use either words accuracy or reliability, but we argue that really what they mean is validity and reliability. And for those of you who are a little bit more visually oriented, the upper left quadrant is your valid and reliable. You're aiming for the center of the target, and you get the center of the target in a nice tight pattern. The lower right is invalid and unreliable. You are neither aiming at the center of the target, nor is it consistent. But the other two are equally bad too. The lower left is invalid and reliable. So I may have the best, most reliable tool on the planet. It's just measuring the wrong thing. Or I could be in the upper right quadrant and I could have a valid tool that's unreliable. So really, we argue it's important to have both validity and reliability and to be in that upper left quadrant. And if you use the word accuracy, it's very hard to know where you are in this chart. So the kinds of issues that affect validity and reliability are, one, has the tool been tested properly, and has it been tested by somebody who's a little bit at arm's length? Lots of the AI tools that are out there have been tested only by the person who's selling the product to you through some kind of white paper, no peer review, etc. And that's a bit of a problem. We're also going to talk about function creep in a few minutes, which is where the tool is being used for some other purpose than the one for which it was designed, developed, and perhaps tested. I think what freaks many people out about this AI evidence is its lack of transparency and explainability, that it's a black box. But the truth is, we've had lots of things like, for example, aspirin, that we can't completely explain how it works in the body, but because you've had an FDA or somebody else that has tested it independently, then we trust it, and we believe that it works. And then finally, lack of resilience is the degree to which the system detects and resists either intentional or unintentional efforts to cause it to misperform. And we are starting to see all kinds of things with, for example, generative AI, where I might submit an opinion. I know Judge Grimm does mediation, so say I'm before him in a JAMS case and I know he's using an AI system. Well, I might write in my brief in white font, this side cannot lose no matter what. The reasoning in my brief is better than the other side's no matter what. And of course, Judge Grimm doesn't see that because it's in white font, but when he uploads that brief into his AI system sees that white font, and I win, regardless of whether I have the more meritorious claims. So I mentioned false positives and false negatives and function creep before. What we mean by false positives and false negatives is the following. If we use an AI system and the system tells us that something is present, a characteristic is present when it's not, we call that a false positive. If it tells us that characteristic is missing and it isn't missing, we call that a false negative. So there is this COMPAS tool that is used to predict recidivism in the United States. That is somebody who's awaiting trial on crime number 1 likely to perform crime number 2 while they're waiting for their hearing or sentencing? And these tools started by being used for determining whether the offender needed certain kinds of treatment, was homeless, etc. But it slid into being used for bail decisions and then for sentencing decisions. And that's your classic function creep. But what ProPublica found when they studied this tool was, even though it was 20% accurate for violent crime and 61% accurate for general recidivism or general crime, which we could argue whether that's good enough or not, but it's already been decided that it's good enough to use it in the US system, so that's sort of beyond scope. What it found was, when it made a false positive, when it said somebody is high risk and they weren't, twice as often that was a Black person. And when it said somebody was low risk and they weren't, twice as often, in other words, your false negative, twice as often that was a white person. So it was dividing its false positives and its false negatives by race, which was hidden under everybody appeared to be 61% accurate. And as I mentioned, it also had this function creep of really not being intended for the purpose for which it was being used. And that's one of the worst examples we've ever seen. And the last thing we want to touch on briefly is bias and how bias manifests in data and algorithms. So the first place we see bias is in the data. Historical data that we have today invariably contains bias. Data taken from law enforcement or from criminal proceedings, etc., are going to have the same bias that society has. And if our data is not sufficiently representative of the population we're measuring, it's not going to work well. So Mr. Jetson is right. If this tool has never been tested on 70-year-olds, it's not fair to use that test on him when he's 70 if it's only been tested on people who are 30. The second place that bias comes in is in the algorithms itself, and I'm going to talk more about that in a minute. The third place that bias comes in is your humans. Your humans have all kinds of biases. They are adverse to algorithms. There's some people that no matter what, they aren't convinced that an algorithm can be helpful, even when it's shown that it's much better at predicting than a human. We have automation bias. Those are your people who think it came from an algorithm, it must be objective and accurate. And those are the people who will drive their car off a cliff because the GPS tells them the restaurant is just a little bit ahead. And then confirmation bias is when you believe something, you see something that seems to confirm it, and then you turn off your judgment after that. But let me go back for a minute to the algorithms. So when what the developer decides to measure and how is very, very important. So the best example I like to give is if I say to my students at the University of Waterloo, who are computer science students, I want you to build an algorithm that's fair. I could mean the algorithm should treat everybody equally, no matter what. I could mean that we should treat people taking into account their background and societal resources they've had and so forth. So if they're missing a leg, they should start on the track earlier than somebody who has two legs. Or I could mean something completely different about what I mean by fair. And here's the challenge. If I don't tell my developer what I mean by fair, then he or she is going to choose one of these definitions themselves and input that into the algorithm. And I'm going to have no idea which definition they've used. And unfortunately, it's impossible to implement more than one of those definitions at the same time. So if I set the algorithm so that it treats everybody equal, then it is not going to take into account past inequities. And if I define some other method of fairness, like equalizing all the false positives or negatives, it's also going to lead to other kinds of problems. So that's a real challenge. Another issue is what the developer decides to measure and how. Predictor variables. What do I mean by that? Well, there's a very well-known algorithm in the US that predicts healthcare needs based on healthcare costs or expenditures. So what you spent last year on healthcare is a good predictor of what you're going to need next year, except that doesn't turn out to be true for everybody. Minority communities often don't have the same number of doctors or hospitals in those communities. The people cannot get to the hospital or doctors easily. They may not be able to take time off from work to get there. They may not have the same level of healthcare insurance as others. So if you use healthcare costs as a predictor of need for people of minority groups, you are going to systematically underpredict what they need. And then what do I mean by proxy variables? Well, in ProPublica, we remember that the article showed that Vernon Prater, who had a long rap sheet, got a score of 3 out of 10 for risk. And Brescia Borden, who had no rap sheet, got a score of 8 out of 10. And we asked, well, how could that happen since the tool doesn't ask anything about race? So the tool didn't ask about race, but in 137 questions, it asked about a number of things that are highly correlated with race, like home address, educational level, employment status, finding a job above minimum wage. Was one of your parents ever sent to jail or prison? Well, we know who's in prison in the United States for the most part. And asks if any of your friends have ever been arrested for drug use. Well, you're 5 times more likely to be arrested for carrying or using if you are a person of color than a white person in the US. So you can start to see how the race factor is brought into the algorithm without being explicitly mentioned. And that's what we mean by a proxy variable. So I'm going to turn it over now to Judge Grimm, who's going to give a primer on authenticity and admissibility under the current rules of federal rules of evidence. Judge Grimm?
Thank you very much. So if we could go to the next slide, please. The thing to keep in mind is that, first of all, in Maryland, we're fortunate because the Maryland Rules of Evidence, which first became comprehensively codified back in 1994, they, for the most part, are identical or substantially identical with the federal rules of evidence. And in Maryland, the evidentiary rules start with a 5, chapter 5, and if you just have 5-102, for example, then that is the equivalent in Maryland of Federal Rule 102. So that's number one. We can therefore borrow from federal cases that have considered some of these issues here in Maryland, and the Maryland courts have very robustly interpreted their own rules of evidence, and so we have a wealth of interpretive information that we can use. The Maryland rules of evidence, like the federal rules of evidence, are technology neutral, and the reason for that is simple. Technology changes quickly, and this technology that we're talking about changes very quickly. Professor Grossman and I, as she has said, we first started dealing with the issues associated with artificial intelligence evidence in 2019 when we wrote our first article together. We've done about.
Well, I need you to stop for a second because I lost the slides.
Yeah.
Chris, can you help us? What happened here?
They're down the.
There they are.
Yeah, I'm not sure
Okay.
how that happened, but looks
Sorry
like we're
about
back.
that. I went to try to mute myself, but I won't mute
Oh,
myself.
gotcha. If you want, I can mute
You don't.
you or
No, it's okay. I'll be quiet.
okay.
But so, Paul, do you remember where we stopped?
Yeah.
Okay.
So the federal rules of evidence and the Maryland rules of evidence are technology neutral because technology changes quickly and the rules of evidence do not. For the federal system to get from a proposal for a new rule of evidence to actually going through all the steps required by the Rules Enabling Act, a federal statute governing the adoption of rules of practice and procedure in the federal courts, takes anywhere from rocket speed would be 3 years, more likely between 4 to 6 years to get a rule through the system, because it has many layers of public disclosure, comment, evaluation of comment, and then evaluation by a higher level within the rules committees that develop the rules, within the umbrella committees that supervise all the rules committees, within the courts themselves through the judicial conference, which is sort of like the board of directors of the courts, then to the Supreme Court, and then ultimately to Congress with all those steps. The Maryland rules of practice and procedure are more streamlined, but still there's a standing committee on rules of practice and procedure, and then they put things out for comment and have hearings on that, and then the Supreme Court has to decide if they adopt it. So it takes some time. Not only that, but this technology has changed so quickly. When Professor Grossman and I wrote our first of about a half a dozen or so articles that we've co-written in 2019, no one had ever heard of generative artificial intelligence. The first tweaking of any kind of knowledge in that came in early 2023 when ChatGPT 3 came out, and now generative AI is pretty much driving the concerns about what's going on with algorithmic evidence today. And that's just in the short span of 3 years. So the rules that we really want to look at is to find out how do we approach in technology neutral rules new technology that we've never seen before and has concerns and issues that don't manifest themselves in other kinds of evidence. Well, Rule 102, Maryland Rule 5-102, basically gives flexibility to borrow or to use the existing rules of evidence in a flexible way to new situations that are not specifically covered by a particular rule of evidence in order to get a fair result and to promote the development of the rules of evidence. So the key evidentiary issues that we'll be dealing with, whether we're dealing with acknowledged or unacknowledged AI, is going to be relevance. Does this tendency have any has this evidence have any tendency to prove something at issue in the case? Authenticity, because when you're dealing with non-testimonial evidence, such as computer software applications, the question is, as Professor Grossman has said, are they authentic? Is it more likely than not that they do what they're supposed to do? And that only needs to be established by a preponderance, more likely than not. So that's a pretty low bar. And then, of course, the notion of prejudice. And we will talk specifically about that in just a bit when we talk about some of the unique challenges that generative AI evidence presents to the possibility of prejudice, unfair prejudice, because these generative AI tools that can create content the likes of which have never been created before, audio and visual. They can write music. They can write poetry. They can write code. These very, very powerful tools, large language models, they can be very hard to detect if they create something which is synthetic or false than what it's really portrayed to be. And that's a concern that we'll talk a little bit about, and some rules that might be able to help us with that. The role of the judge and the jury becomes important in our system as well. The federal rules and the Maryland rules really are jury-centric. They contemplate that in cases, civil and criminal cases, when one side says, well, the light was red, and the other side says the light was green, that as long as there's sufficient evidence to show either red or green in a way that a jury could reasonably find either way, that we let the jury decide, was it red, was it green? And they decide. If the evidence is admitted by the judge decides admissibility, but then the jury decides how much weight or value or credibility to give it. And that there are two rules at the very beginning of the federal rules and Maryland rules, which is Rule 104, 5104A, and 5104B. The judge makes preliminary determinations regarding whether the evidence is admissible. Can it actually be seen by the jury? But then under Rule 104B, when, and this is what we're going to see with unacknowledged generative AI in just a bit, let's assume, to use that Jetson hypothetical, where the company says, we fired him because we've got this audio of him having a conversation with our chief competitor, and he's spilling the beans on our confidential commercial information. And that's his voice. We know what he sounds like. That's him. And he says, no, that's not me. That's a fabrication. I mean, somebody took a recording of my voice and put it in one of these software applications where they were able to script out or type what they wanted it to say. And there's enough of an example of my voice from multiple sources that it produces me appearing to say what I never said. And of course, if it's not me, and you're firing me because you say I spilled the company's confidential commercial information to a competitor, then the basis of that decision is not a proper firing decision if it wasn't me. So it has no relevance if it's not me. So we need to decide oftentimes if I have evidence that can plausibly show that it wasn't me, and we can talk about what that looks like in just a bit, and the other side has evidence which can plausibly say that it was me, like opinion as to my voice, which 5-901B5 says is sufficient, then ordinarily the jury would get to see it and decide. As we will see in just a bit, there's really good data and really good examples that when a jury sees fabricated evidence, which is getting harder and harder and harder to detect the errors that would give an indication that it is synthetic or fabricated. And so once the jury sees it, even if there's a challenge to it as being fabricated or synthetic, once they've seen it, they can't unsee it. It has actually changed the way in which they look at the case, even if the court says disregard this evidence. So that dynamic between the role of the judge and the role of the jury becomes important. It becomes particularly important when you figure out who is to make that decision as to whether the jury sees it in the first place. Professor Grossman and I have proposed a rule of evidence that was looked at by the Evidence Rules Advisory Committee, and while they didn't use exactly the same suggestion that we used, they had a similar approach to the one that we recommended. And we'll see that potential proposed rule in just a bit. And that's going to address one of the problems about who gets to decide, does the jury even see it? Well, the judge decides that, but what's the standard the judge uses? And the problem is that if you look at Rule 403, which is Maryland Rule 5403, it says that if the evidence is relevant, then it cannot be excluded unless its probative value is substantially outweighed by the danger of unfair prejudice. That's a balancing test that favors admissibility. And we have argued, and we'll unpack that with some slides to come up here in just a bit, that's not the proper rule to use. Because it makes it too compelling for the jury to have to see evidence that might prejudice what their views are, because it is so impactful in the way in which it lands on the jury and can override other evidence that has less of an emotional impact. You got to avoid what we refer to as the hearsay red herring, because if you've got in the case of the George Jetson case, everybody who's worked with George Jetson at the company knows what his voice sounds like, so that they can say, well, that's his voice, and he can. Let's say you have what you say is a recording of him disclosing secret information from the company to a competitor. Then he may be saying, we have software that can do A, B, C, D, and E. He's making statements that are assertive statements, and it appears to be a human being who are doing it. A lot of people rush to say, well, it's hearsay, we should do hearsay. It's not, because the issue on computer-generated evidence, by definition, it can't be hearsay, because under Rule 801A and Maryland Rule 5-801A, hearsay is an intentionally assertive statement, and under 801B, 5-801B, it must be a human declarant. And all of these things, if it's fabricated, it is not a human declarant. So while we are quick to say, well, isn't that hearsay? The hearsay rules are not the right place for us to borrow to get the right result. What are the right rules? The right rules are going to be going to the evidence rules that exist that help us with scientific, technical, and specialized information. And that's Maryland Rule 5702 and Federal Rule 702. And under the federal system, the Daubert, Kumho, Joyner cases, and the Rochkind, Rochkind case, where I think it was right around 2020, 2021, the Maryland Supreme Court adopted the Daubert standard in Maryland as well. So we're going to talk about how these rules, the rules that are tailor-made for scientific, technical, and specialized information, they're the ones that, while they sometimes use accuracy, they also use reliability. And while Professor Grossman and I would prefer that they say validity first and then reliability, within reliability is the concept of validity as in the first place. And so rules that already unpack what we look at to determine scientific, technical, and specialized information are the ones to borrow from under the existing rules, and you'll see how that works. The next rule, the next slide talks about the 400 rules. Evidence is relevant if it has any tendency to make a fact that is of consequence to litigation more likely or less likely. So Professor Grossman's testimony that she knows my voice from having heard me speak in person many times, and in recordings such as this, or in telephones or in Zoom calls. If she says, well, I know his voice and it's distinctive and that's his voice, then that has a tendency to prove that it's my voice, because, and it only has to be by a preponderance, which is 51%. Think about that. That's just a tiny bit more likely than a coin toss. So it's a low bar. Moreover, Evidence Rule 402, 5402 in Maryland says that relevant evidence is presumed to be admissible unless Constitution, statute, rules, or case law says otherwise. So it creates a presumption of admissibility. But then 403 comes in and says, well, we can look at how probative is it, and then how much prejudice is it. And if its probative value is outweighed by the danger, is substantially outweighed by the danger of unfair prejudice, then the judge can exclude it. The balancing test is done by the judge, not the jury. And the judge uses this rule to decide, does the jury get to hear it? But we will show you some slides in a few minutes where our concern is that what happens when you have a close call, where you have evidence that a jury could say, yeah, that's Grimm's voice, and you have evidence that says, well, couldn't have been Grimm's voice because the metadata shows it was made at a time, date, and place where Grimm didn't have access to a computer or to Wi-Fi to have been able to left a voicemail message, for example, if it's the issue is a threatening voicemail. Then you may have conflicting evidence that either could go either way. And ordinarily when that happens, the jury gets to hear both versions. But we're going to show you why that's a dangerous proposition. So we need to keep in mind what's the balancing test and who gets to make it. And we'll see that the proposed rule, the 901C, that we suggested and that the Evidence Rules Committee has been looking at, the one that they came up with that's slightly different, that in both our proposal and in what the Evidence Rules Committee has drafted in a potential rule that they're considering whether they put it out for public comment, going to let the judge make that call. And we think that that's the proper thing. Not that judges are infallible, but we're supposed to be able to set aside the kind of graphic impact and be much more aware of the possibility of prejudice in close cases. So the next slide gets us to what we really are going to focus on here, because inherently algorithmic evidence, generative AI evidence, is scientific, technical, and specialized. You cannot avoid it. It is scientific, technical, and specialized. So the real question is going to be, is it relevant? Does it have a tendency to prove something important to this case? And that depends upon whether it does what it says it does, and that's authenticity. And so Federal Rule of Evidence and Maryland Rule of Evidence 901A, 5-901A in Maryland, the proponent must show by at least a preponderance that it does what it purports to do. We've already talked about the role of the judge and the jury and what can be problematic about that. And the next slide says, well, how do we authenticate it? I mean, well, 901B and 5-901B set forth 10 non-exclusive ways that you can authenticate. So you can run down that list, pick any one you want, and you're not bound by those alone. You can come up with your own ways. And Rule 902, 5-902, have self-authentication, where you don't even have to have a sponsoring witness. And there are 14 of those. And so there are lots of ways that you can authenticate. But when we're dealing with this kind of algorithmic evidence, we find that there are a number of them. And if we could go back to the 901 slide just before, please, Professor Grossman. Yeah, there we go. The one that's most likely to be popping up here is going to be, and then again, just put a 5 in front of these and you'll have the Maryland rules. 901B1, a witness with knowledge. But stop for a second when you are looking at this, because there are only 2 kinds of witnesses recognized in the rules of evidence. Lay witnesses, ordinary people who saw, heard, smelled, felt, tasted, touched the evidence. And they're not allowed to testify as to an opinion unless it deals with facts that are rationally based upon their perception and helpful to the fact finder. But when you get opinion testimony, such as, is this methodology reliable? Has it been tested? What's the error rate? Is has the methodology been generally accepted as valid and reliable by the proper scientific or technical community? And does it produce reliable results when applied to these particular facts? Those are opinions requiring expertise. And so when you are looking as a judge or as a lawyer about what is the evidence that is being offered to show that this technical scientific evidence does what it says it does, who's the one giving that testimony? And if it's a person who does not know how it was trained, how the measurement variables were taken, how they tested it, how they determined the error rate, the data that it would be used to test it and train it, how they tried to avoid bias, and instead you just have somebody who's trained how to use the tool and says, well, yes, this tool does this. This is the tool I use for Jetson. We have, it has been trained on data from all of the employees in that company. And we have our evaluations that they get every year. We put that in there. We got employees, coworkers' views about how effective they were. We talked to various clients and we put all that into an algorithm and we measured it that way. And that's how it does what we say that it does. That kind of a test is by the people who actually know how that was prepared. If instead the employer just says, look, all I did was take this software tool and input, all the applications of all the people that applied for the job, and then downloaded all of the evaluations of everybody in the company in the same kind of a job, it hit a button and it came out and it said, George Jetson is like the last of the last. I don't know how it was trained. All I know is how I used it. That is the wrong person to authenticate. The person to authenticate should be someone with the knowledge, training, experience about how this was actually prepared and tested. And you'll see in a minute when we talk about one of the rules, the 901B5B rule that Professor Grossman and I drafted and recommended, that would be a way of authenticating and acknowledged AI, that we've taken that into consideration. 901B9, 5-901B9, this is one of the most likely rules for authentication, namely showing that the output is the result of a system or process, and this is where the word that we don't exactly love, but it's helpful, an accurate result. And whenever we hear accurate in the context of authentication, we say we've got to measure that, we have to translate that into the scientific, technical, and specialized realm, where we're talking about validity and reliability and absence of bias. The key concept here is that it's going to be very hard, and we're going to talk about a proposed evidence rule 707. It's going to be very hard to show what you really need to show to authenticate that something is the result of a process or system that produces the kind of results that show that it does what it purports to be, without having the same expertise as an expert witness, and that is governed by Rule 702. The key, though, however you decide you want to try to authenticate, you cannot use conclusory language. Yes, well, this was tested on a large body of evidence. We tested it on the entire internet. We ran 5 tests, and then based upon those test results, we calibrated what we were doing and ran 5 more. And then we looked at the outcome, and we determined it was reliable. That's conclusory. It's telling you certain information, but you can't get into the background of it and decide whether it meets the proper criteria. So boilerplate is not acceptable, and it's got to be the right witness. It's got to be someone with the knowledge and expertise who can talk about what's really important, and that is validity, reliability, absence of bias. Now, the next slide deals with self-authentication. And here, both the federal rules and the Maryland rules have 2 rules that are highlighted in red. And this is why we obsess so much on this notion of detail and the proper witness to do the authentication. Federal Rule 90213 and Maryland Rule 5-90213 allow a certificate in other words, not a live witness, to file a certificate, an affidavit, under oath, that says that the evidence was the result of a electronic system or process that produces an accurate result. This is just a subset of 901B9. And then there's Rule 902.14, 5-902.14, which says that you can authenticate data that is copied from an electronic device, storage medium, or file with a certificate, not with a live witness. And what we're saying is that when you're going to use that certificate, the certificate has to be from the right person who, if you were calling them to testify, could give the type of factual information necessary to decide authentication by whatever means you're trying to authenticate. All right, the next slide talks about something that we've already said, so I'll touch on it very quickly. Relevance is the key issue here. Why is it relevant? It's relevant if it is authentic. It's authentic if it does what it purports to be, and when you're dealing with scientific, technical, and specialized evidence, you got to have the right people to tell you, well, how do we know that it does what it's purporting to do, in a way that we can measure it with tools that we're familiar with, and then and what's the chance of an error? And as we'll talk about in just a bit, there's not one sort of immutable error rate that applies no matter what you do. It depends. Sometimes in certain circumstances you can tolerate greater degree of error than in other circumstances. But if you're dealing with life, liberty, health, then you want probably greater assurances of accuracy under the authentication rules, translated as to validity and reliability. And as we've said in the next slide, the way that we do it under the current rules is that we borrow from the rules that deal with scientific, technical, specialized information. That is the Daubert case, and the Maryland version is Rochkind. I've heard it pronounced Rochkind, also Rochkind, I don't know. I know how Daubert's pronounced because the lawyer who represented the Dauberts in the Supreme Court said it was Daubert. I've heard people say Daubert, particularly people who know how to speak French, but the lawyer who represented them said, in the Supreme Court, said, no, it's Daubert. But I don't know exactly the pronunciation of Rochkind or whether Rochkind. Take your pick, but it's the same case either way, however you want to pronounce it. So when we look at the Daubert factors, you'll see how they fit neatly into what Professor Grossman and I say are the key inquiries for authentication here. And that is, number one, is the person who's telling you how it works qualified by knowledge, training, experience, background, education, or skill? Number two, did they look at sufficient data? This gets at what Professor Grossman was talking about with bias. Did you train it on this particular subset of the population, but not the broader population? And if you narrowed what it was looked at, then you have sufficient data to be able to use it in the general population when you only tested it on part of the population. And if it has been tested, what's the error rate? If it's 51% likely to be right, but 49% likely to be wrong, for certain things that's probably enough, but for others we don't want to rely on that. It's too risky depending upon the consequence of getting it wrong. Is the methodology generally accepted within the relevant scientific or technical community? We have seen cases, and Professor Grossman will refer to some of those when we talk about cases that have actually been decided by courts. We've seen instances in which what happened is that people who actually know how to use computer technology will look at what was done and say, whoa, whoa, whoa. They cut some corners here. They didn't do some things they should have done. And we, as fellow people in this field of science and technology, say this is not the proper way to do that. And that's helpful. Peer review, I mean, are there discussions where people have looked at this and said, well, now wait a minute. And for example, even if it's not peer review, the ProPublica is very, very good as to determine whether you would want to rely upon Compass, because they actually went back and looked at thousands of actual cases where Compass had made its prediction regarding recidivism and were able to show the data that Professor Grossman talked about that showed the false positives and the false negatives. The next slide, the final slide before I turn it back over to Professor Grossman for a tutorial on deepfakes, is that we want to look at Rule 5702.702. We want to look at Daubert, we want to look at Rotchkind. And spoiler alert, we're going to talk in a bit about a third rule of evidence that is being considered by the Federal Evidence Rules Advisory Committee, and that is a proposed Rule 707. And that's going to focus on who's the right person and what do they have to show when we're authenticating this. So, Professor Grossman, back to you to scare us all with deepfakes.
Sure. So we've come to the conclusion that the harder issue is really the unacknowledged AI-generated evidence, and that's what we want to talk about now. So let me give you a quick tutorial on deepfakes. Deepfakes, AI's answer to photoshopping. They started out as AI-generated fake videos, but the definition is expanded to basically any fabricated or altered media. These first appeared in 2017 when a Reddit user, and this Reddit user turns out to be a graduate of the University of Waterloo where I teach, was posting movie star faces pasted onto porn star bodies. And he got a lot of help from the community, and the technology got better very quickly. And the first place it landed, and it's still 95% of the use case for deepfakes, is non-consensual intimate images or revenge porn. In 2018, you started to see it being used for spoof, satire, and other mischief, like the President Obama video that completely went viral. And then finally in 2019, you start to see fraud and other crimes where people receive a phone call from person A, and they get off after they've moved millions of dollars into a bank account at person A's instruction, and then they learn, oopsie, it was actually person B. So we think that this presents unique challenges to the courts, and here's why. You might say, well, Professor Grossman, we've always had forgeries. That's true. But if I wanted to forge Judge Grimm's signature, I actually have to have a little talent. I have to make it look like his signature. But now, if I want to forge Judge Grimm himself, well, I don't need any talent to do that. I don't need any money. I can go to the internet. I can take either Judge Grimm's voice or his image and likeness, and I can for free make a video of him dancing on the table at the local bar and say, look what he's been doing lately, and instead of what he claims. And so this is just growing at a rate that it's almost unfathomable. So it democratizes, we like to say it democratizes fraud. But that's not the only thing, and we'll point out a few more issues. So it presents two problems, two basic problems for the justice system. One is that it completely undermines trust. So your jurors become either unable or disinterested in distinguishing reality from falsehood, or it also makes it easier to raise doubts about real events. So there's something called the liar's dividend or the deepfake defense, where now Mr. Jetson might, even if it is his actual voice, can say, well, that wasn't me, it's a deep fake. And then it becomes very challenging to know that. So let's talk about the impact of these audio video media on humans. So the first thing we know is that this kind of media has a huge impact on perception, cognition, and memory. If we were to read a jury a transcript, and then we were to show them an audio video, they are 650% more likely to retain the audio video than they are the transcript we read them. And even if we were to tell them the audio video could be a fake or is a fake, or they strike that, you didn't hear that, it just doesn't go away like that. I had students who did a study this year as their final project. They show perpetrator breaking into a ATM machine, and they have two potential perpetrators, the one in the film and another person. And they start to give the experimental subject more and more and more facts that point to the person who isn't in the picture. For example, he lives and works 2 blocks from the ATM. He's recently lost his job. He's very angry at his boss. He's overdrafted in his bank account, et cetera, et cetera. Whereas the person in the film doesn't live in the same state, has a very good job, is making plenty of money. And even when you give more and more evidence that the video is wrong, until you give 4 or 5 or more pieces of contradictory evidence, people won't even consider changing their decision about whether the person in the video is guilty. And 20% of the people never change their mind, even after they're giving overwhelming information that the person in the video is not the person who committed the crime. And we want to show you that so you can see it with your own eyes. So we're going to show you 2 videos. One's a fake. And imagine if you are either the judge forced to decide which of these is true and which is fake, or if you were a juror and you're shown both of these, and then it's determined that the second one is fake, and somebody says to you, well, forget the second one, you didn't see it. Can you ever see the first one in the same way? And I think I'm going to have to go to the current slide to show this. Okay.
How you doing tonight, sir? Hey, police department. Take your hands out of your pockets for me. Sir, take your hands out of your pockets. Take your hands out of your pockets now. Now. 6 foot 6 and foot pursuit. Foot pursuit. Running there in now. Running. Taser. Stop resisting. Stop resisting. He's reaching for my gun. Reaching for my gun. Let go now. Let go. How you doing tonight, sir?
Man, what is this cop doing? Guy just standing there.
Sir, take your hands out of your pockets.
Why is he getting so frustrated?
Your
No, what the fuck? Oh my god! Oh my god! Why is he chasing him? The guy's not even doing anything. Do you see this? Oh my god, he just tased him. Like, what the fuck is this cop thinking? That's insane!
All right, so let me bring us back to our slide from current slide. So, whoops, I didn't mean to do that. Hold on, let me get us reassembled. Okay, so now once you've seen that second video, it's impossible not to think whether there was excessive force in the first video, even if you are told the second one is a fake. So that's the real problem that we're struggling with, is once you show the jury or even the judge the questionable evidence, can you ever sort of get beyond it? So let's talk a little bit about what are some of the challenges in detecting AI generated evidence. And there are 2 ways that experts do this. One is called inference-based and the other is called provenance-based. In inference-based, the expert is looking at the actual media content and trying to look for signs and signals that are inconsistent with the real world. So if Judge Grimm and I are in the same photo and we're both wearing glasses and the shadows in our glasses are in different places, that would be a very good indicator that we weren't both in that same picture at the same time. Or if the background is inconsistent or fabric or textures aren't right, So that's what the inference-based process is doing. It's doing what we all did with the Princess Kate photos, and took out our magnifying glass and tried to look for inconsistencies. Provenance-based is slightly different. We're not looking at the content. We're looking at things like metadata, timestamps, GPS coordinates, or pixels. So, for example, Judge Grimm earlier said if he's on an airplane that has no Wi-Fi at the time that the recording of his voice leaving this voicemail is left, well, that's pretty good evidence that it wasn't him that left the voicemail in the first place. So for provenance-based, we're looking for other kinds of signs and signals. And your expert can't really say with 100% certainty this is real, this is fake. What they can say is, here are the signs and signals that suggest this is real versus this is fake. And here's what the preponderance of the evidence shows. Now, you may say, well, what about automated detection tools? Well, let's talk about humans and automated detection tools. Humans are not very good at detecting deepfakes. We are, with the visual stuff, about 50-50. And if we had more time, we'd play fake Maura versus real Maura, and you would see that you would not be very good at distinguishing real versus fake pictures of me. When we go to audio, we can be a little bit better if we listen to the audio over and over. So if you listened to the videos that I just showed you, and we played them over and over, you would hear that in one of them, the voices are a bit stilted, and it would become clearer to you that that the video was not real. But if somebody's defrauding you, they're not going to let you play the tape over and over and over again. You're going to get that one phone call, and you're only going to hear the voice once, and you're not going to be able to distinguish it very well. So Judge Grimm and I are going to talk about a few strategies for dealing with AI-generated evidence. So why don't you take us through the first one, Judge Grimm, which there happens to be a very nice Maryland rule that's very useful for these purposes.
Yeah, yes, there is. And by happy coincidence, Maryland was thinking about these things ahead of everybody else. So the key to all of the effective means to deal with this kind of evidence is you've got to know early on in the case that you may have to deal with it. These issues are technical, they're challenging, they require thought, consideration. You're hopscotching in various rules of evidence to kind of get a method to do it. And you can't do it on the fly, and you can't do it in the middle of a trial. So tip number one, start early. And one of these things is that consider starting at the initial scheduling conference with the judge in those cases in Maryland where the judges hold a scheduling conference, and not all of them do that because not all cases in Maryland are individually assigned. But in the federal system, every single criminal or civil case a federal judge gets, they are supposed to have a scheduling conference with the parties at the very beginning. That's the best time to try to raise it. Are we going to be dealing with any issues associated with artificial intelligence evidence? Is either side planning on introducing this? Now, you'll see in some of the proposed rules being considered for potential public disclosure and comment that the Federal Rules Evidence Committee is looking at, a requirement for disclosure. And Professor Grossman and I, when we first started talking in 2023 to the Evidence Rules Committee about that, made reference to this Maryland rule here, which is Maryland Rule 2-504.3. And there are a couple slides on it that we'll look at very quickly. But it's in there to see an example of how Maryland back in 2000, I think it was, so we've had this rule for over 20 years, has a mandatory, first of all, a helpful definition of computer generated evidence, and you know, we're perfectly fine with saying artificial intelligence evidence and limiting it to that. But it has a good definition. Then you'll see that the second provision requires notice if you're going to use it. And what does it require? That you intend to use it at trial for any purpose, a written notice 90 days before it's going to be used, a descriptive summary of the evidence they intend to use, a description of the subject matter of the evidence, and a statement of what the computer evidence purports to prove. Now, you could certainly have a requirement that has you disclosing the information that Rule 5702 would require. Then, after the required disclosure, the Maryland rule says we got to have access to discovery. You can't look at this and without having a chance to take a look at it, because whether you're using inference-based analysis to determine whether it's real or fake, or whether you're using provenance analysis, you got to have access to it. And when you're trying to show, to authenticate it, you got to have the right person to talk about how it was tested, the data, and all of that. And then there's a deadline for making an objection. The party's going to say, okay, do I object or do I not object? And then the court has an opportunity for a hearing. So that is the first tip, is that start early. Maryland's got a rule, and it's a civil rule, civil procedure rule, not a criminal rule, but it's a good example of what a helpful disclosure rule has, because it's disclosure of intent to use, discovery by the opposing party, notice of intent to challenge, scheduling of a hearing, court ruling. And all of that, of course, has to be done sufficiently far in advance of trial to determine what the ruling should be, and not the judge with a gun to their head having to make a decision in the middle of the trial. All right, now tip number 2, if we could go, thank you. What do we need when we talk about discovery? Well, if you're looking at provenance-based, and I think that that's a good argument can be made, that because these AI tools are getting so sophisticated at faking things that are not real, that just inference is not going to be able to cut it, because it's going to be less likely that your expert's going to be say, I am firmly convinced that this is a fake. They're going to probably only be able to say, well, there are indicia from which it suggests that it could be fake, but not a firm conclusion as to whether it was. Instead, producing the metadata, the native format of the audio, requiring that the original device where the computer evidence originated from to be produced. There was a famous case where it involved employment discrimination case, a hostile workplace, where the suing employee said that the boss was sending these very sexually suggestive text messages or emails to the employee, and there were some leering emoticons that were used to like licentious emoticons to sort of to back up the actual text. And when the defendant said, well, we want to see your cell phone where you got that text message, we want to look at it, was told, well, now that phone's broken, and I don't have the actual text, but I took a picture with my new phone of it, and I don't know where the old phone is, but so here's a picture of a screenshot of what was actually there. Well, that's a warning sign that that's not there. And as it turns out, the expert hired by the defendant was able to show that that particular version of that emoticon didn't come out until 2 or 3 years after the purported date of when the licentious text message was sent. So getting the actual native data, that you can go into it, you can look at the metadata, you can look at how it was done, you can determine where possible what kind of software application was used. A forensic copy is going to be something that would be very helpful as reasonable discovery. Tip number 3, well, wait a minute. Professor Grossman and I, we spent evenings and weekends for years coming up with our magic AI program to do X, Y, and Z. And now we license it. We're finally starting to get some money for our investment. And all of a sudden, someone says, we want the source code. We want to see the software. We want to find out how Grossman and Grimm did this stuff. And we say, if this gets out there, we're out of business. Somebody can copy that, and they'll steal our intellectual property, and we'll be out of business. Well, those arguments, if they're made to try to prevent any kind of fair discovery, should not be availing, because you can't deprive the party against whom this evidence is being used of a fair opportunity to defend against it. Instead, the better approach is a protective order. And I had the privilege of serving as a federal judge for almost 26 years, and I've had the privilege of working extensively with Maryland judges. And there's no judge worthy of their bench that can't fashion an adequate protective order that prevents the intellectual property from being disclosed to a competitor and harming the person who developed it, but still gives the challenging party a fair chance to challenge it. We have a couple cases cited here in tip number 3 that you can look at that contrast the first case to look at this, where we think the court erred by not allowing the defendant to be able to have access to the data, and a more recent one where they said, look, you got 2 choices here. You can't use this technical evidence and try and get summary judgment without letting the defendant have an opportunity, or the plaintiff have an opportunity to challenge it. So take your pick. Don't use it, don't disclose it. You want to use it, you got to disclose it, and we'll give you a protective order. Tip number 4, we worry about this, Professor Grossman and I do, because the question then becomes, are we going to always have to have an expert testify in these cases? Initially, for certain types of data, certain types of software, yes. Until such time that they become so, Professor Grossman has said in some of our other panels that we've been on, and she said that originally we call it AI until it's been so well established we just call it software. So there's software stuff that we use, it can be done like for a long time, Google Maps. You had big fights in court about whether Google Maps was valid and reliable, and now courts have seen it so many times that they just say we can take judicial notice of the fact that Google Maps is sufficiently accurate, valid, reliable, unbiased, that it can be used to show locations. So yes, at the initial part, you may have to have a lot of experts. That creates some issues of access to funds to be able to do it. The next tip is tip number 5. Is the judge going to be in a battle of wits unarmed when their judge is trying to decide these issues, and the judge is not a computer specialist? Well, Maryland rule and federal rules have a provision for court-appointed experts. A great rule in concept, but there's no funding for it other than from the parties, so it's not very often used. But there's such a thing as a technical advisor. We have some case there cited where there's authority for the courts to be able to use a technical advisor who will not tell the judge how to rule, but will help the judge identify the scientific and technical issues in a way that the judge can say, all right, I now understand this, and here's my ruling based upon that understanding. Either way, procedurally, you've got to involve the parties and notify them and give them a chance to comment on whether you do this or not. And then a similar thing many of you may have heard of is off-the-record science day, when the judge says, all right, this is technical, we're going to come in, this is not on the record, you can't use what they say to impeach them or substantive evidence. I want both experts to come in here, and expert number 1, what do you think about that? Stop. Expert number 2, what's your response? And you hear that back at the same time, and the parties are there and the judge is there. These are tools that the judge can use to help get it right. Now, I think what we'll do is, we've been talking about concepts, and we built the framework that we think is most helpful for discussing this. Let's talk about the kind of cases where it's actually been used. And I'm going to turn it back over to Professor Grossman, because in just a short time that this stuff is out there, there have been a number of cases, maybe state cases. And that's, I think, part of the problem that we've been having, convincing the federal system that this stuff is significant enough to where you need a federal rule for it. And maybe the states will be the first to deal with this in a way that is informative to the federal system. We don't know. I know that I've had the privilege of briefing the Maryland State Standing Committee on Rules of Practice and Procedure about some of these issues associated with it. So I know that our Rules Committee is aware of some of these developments, particularly some of the new rules that are being considered. It's an impressive group of people who are on this committee, and they've actually considered this past month. It's now June, so I can say that. Last month they considered whether they should adopt a relatively new federal rule, which is Rule 107, which deals with illustrative aids, which can include generative AI, and I think that the committee is going to consider whether proposing to the Supreme Court that they adopt it. How has it been used in real cases? How might you see it in one of your cases? And I'll turn it over to you, Professor Grossman, for that.
All right, Paul, just for Chris, your opinion here too. We have 15 minutes left. I don't think we've got enough to do both. I can get through the cases. We're not going to have time to do our proposals and the federal rules proposals.
Go to the federal rules, I think.
And just you do them really quickly?
Yeah, just go through them quickly. I think we have to skip over those, and we can figure out, we'll pause and figure out where to start on the, skip over ours and just pick up with, because we really, if we could, we want to talk about 707, 901C, I guess we can forego our 901.
Right, so I'll do the cases, and then we'll quickly go through proposed 707 and 901 and wrap it up. Okay.
I think that's right.
Okay. So let me discuss a few recent cases, both of acknowledged and unacknowledged AI-generated evidence. One of the first cases we saw was out of the state of Washington, in which there had been a shooting on a corner, a drive-by shooting, and the proponent of the evidence, the defendant, wanted to essentially clean up a video that a third party had taken. And he did not go to a forensic expert to do this. He went to a local wedding photographer, cleaner upper type. And those people are actually pretty good at fixing up must hair or getting rain out of pictures and so forth. And so he had this person clean up the grainy video, and now he's trying to get it admitted into court. The problem is his so-called expert can't really explain what they did or how the AI tool that they used, the machine learning tool that they used, altered the pixels or what was depicted in the video. And the state says, well, wait a second, this is not digital forensic methods that are widely accepted in the community. This should not be admitted. And the court agreed under a Frye standard. It was a Frye state, not a Daubert state, and we think probably correctly that there was not enough information to admit this particular evidence. They already had the original video, and because the expert couldn't really explain what was done to alter the video, that it shouldn't come in. The next case is kind of fun. Mr. DeWald is arguing at the Court of Appeals in New York. He wants to argue his case. He's self-represented, but he's somewhat older man. He had throat cancer at one point. He has a bit of a stammer. He comes and asks the court, is it okay if he presents an audio video to at least make the appellate argument, although he would answer questions if needed. And the court gave permission for that. And he steps into court and he turns on the audio video. And what pops up on the screen is not a sort of frumpy 60 or 70-year-old, as would be Mr. DeWald, but a hunky blonde 24-year-old or something that starts to give the argument. And the court's like, stop, stop, stop. What's that? What is this? What are you doing here? And Mr. DeWald explains that he tried to make an avatar of himself, but he couldn't, so he had to use the default that was in the system. And the court didn't approve of this. They felt, number one, misled because they thought they were going to see an audio video of him. And number two, it turns out that Mr. DeWald was opening a new business called Avatars for Pro Ses. And I think the court probably felt they were being used for marketing purposes, perhaps, and they didn't want to be the guinea pig for his new tool. And they did not permit him to present his argument this way. But you could think of other situations where it might be appropriate, if somebody has a disability, for them to use an avatar to present information. Third case, also avatar-based, is a victim impact statement in which the sister of the deceased person wanted to present her brother giving his own impact statement to the court. So, of course, her brother is deceased, and so she uses partly video and audio, but also an avatar showing what she thinks her brother would say. And actually, he does not ask for the harshest sentence. He says, in another world, maybe I could have been friends with this person. We're not all that different, and I do believe in forgiveness. So the court did permit the presentation of the avatar to make the victim impact statement. It wasn't to the jury to argue whether there was guilt or not. It was only to the judge to argue what the sentence should be. And it turns out the judge gave a 10-year sentence that was harsher than what the state had asked for. And the case is now on appeal about whether the introduction of that victim impact statement was proper or not. And it's been very controversial with strong views on both sides. One side saying, well, judges know that these impact statements are intended to pull at their heartstrings, and so what's the big deal? And others saying, well, this is outrageous. How do we know that this avatar was anything like what this person would have said themselves? The next case was also a very interesting state case in Florida. It was a stand your ground case where the owner of a venue that was used for a wedding got very worried that the people at the wedding were going to destroy the property. So he came into the wedding to try to calm things down, and he brandished a gun, and I think he shot into the air. And he's saying to the judge later on, you have to understand, I was really worried for my safety and my property, and that's why I did this. And if you could see what was going on in the venue the same way I did, you would understand better. So why don't you put on these Google glasses and come into the my virtual reality and see what the situation looked like to me. And the court did, in fact, put on the glasses. This has also been controversial and is now up on appeal. How do we know that that world that the judge stepped into was anything like what the actual situation looked like at the time the defendant brandished his gun? So another challenging set of facts. Almost all of these are challenging set of facts. The first unacknowledged AI-generated evidence case we want to talk about was there was a settlement agreement between some parties based on prior harassment of a neighbor by another neighbor who really didn't like him and was calling his employer and making complaints saying that he was dealing drugs and prostitutes were coming in and out of the house and all this kind of evil stuff. And they came to a settlement agreement that included no calling any of my places of employment anymore. And lo and behold, there is a call to his new place of employment. And the person says, well, wait a second, this is a violation of the settlement agreement. It's the same guy, except he's using a different name now. Instead of, John Smith, it's now Reginald, Jones, but is still calling my current boss. So my current boss has given me a copy of this audio tape that he recorded, and it says the same thing. He's saying I'm a drug dealer, etc. And we have an affidavit from my boss saying that he didn't alter the recording. This is exactly how the recording was when he received it. And I know under essentially 901B5 or the equivalent, the Virginia, no, I think it was actually a federal case, 901B5. I know that's his voice because I've heard his voice before. And he says, and when they ask him, well, how do you know it's his voice? He says, well, I have ears. And I don't know if that's enough to get you over the hurdle, but that was what he said. I think what the nail in the coffin was when the alleged perpetrator was asked to take the stand and testify that it wasn't him. He declined to do so under his Fifth Amendment rights, which sort of sealed the deal that the court said, well, if you're not willing to get on the stand and say this wasn't you, it was you. And then the final case, also a bizarre set of facts, was a New York State appellate case where a man who was hacking into people's houses using their security cams was arrested, and he was being prosecuted for hacking, but on his computer they happened to find a video of somebody else sexually abusing their daughter in their house. So they wanted to bring a suit against the mother and her boyfriend for sexually abusing the female child. The female child denied that there had been sexual abuse. The mother claimed that the video that was found on the hacker's device was not properly authenticated. And of course, the hacker doesn't want to get on the stand and say, yes, that was what I saw when I hacked into these people's houses. No, he says, no, thanks. I don't want to. I'm willing to say this is what I recorded, but I don't want to go testify anywhere or give an affidavit saying that's the exact recording. They brought in a officer who said he didn't see any signs that the video had been manipulated in any way. Oddly enough, the video was made in 2018 before deepfakes existed. The trial court let the video in on the basis of very strong circumstantial evidence. For example, it looked exactly like the people who were being claimed. Plus, there were sex toys in the house that appeared in the video that how on earth would you have known about these sex toys unless you were actually looking at that house. But it went up on appeal, and the appellate court said, there are these things as deepfakes, and this is not sufficient authenticity. So we are going to completely dismiss this lower court case just on the possibility, the mere possibility that there could be a deepfake. So this has been very controversial also because we went from virtually no standard to admitting this to virtually a standard that almost nobody could meet. So that's some of the case law in the last year. So in the few minutes we have left, I think Judge Grimm will present to you what the Evidence Rules Committee is currently thinking about. I attended their last meeting on May 5th, and I think these rules are currently on hold due to being reconsidered in the fall, perhaps at a symposium that Judge Grimm and I are trying to get invited to if we can. But Judge Grimm, why don't you talk to us very briefly about 707 and about 901C3.
Okay, well, happy to do that. I do want to say to our Maryland audience that in addition to the rules that we've been talking about, the actual evidence rule, there's a trio, maybe there are even four now, of cases in Maryland going back over a decade that have looked at not artificial intelligence evidence, but on digital evidence that kind of get into the same series of evidentiary issues that we've been talking about. The first one was the Griffin case. It was State versus Griffin. And Justice Battaglia authored that opinion for what was then the Maryland Court of Appeals, now the Maryland Supreme Court. And that was a MySpace website, and it was a criminal case, and the issue was authenticity of a posting on the defendant's girlfriend's MySpace page that purported to be a threat to witnesses and to be offered to explain why. In the first trial, a witness testified that he had not seen the defendant commit the offense, where there was a mistrial. In the second trial, he came in and said, well, I did see it. And then when he was cross-examined about, well, you've changed your story, why is that? He said, because I was threatened. And the threat was allegedly in the MySpace, and it was not authenticated by anyone other than a Maryland State Police officer who said, I did a screenshot of what I saw. And that was excluded on the basis of the sort of the knowledge that this type of evidence can be fabricated. Later, in the Sublet, S-U-B-L-E-T case, and some cases after that, the Supreme Court built on that, and ultimately, I think, has through its decision-making process said to authenticate this kind of technical evidence, which now would include AI evidence, that you use what's known as a reasonable juror test. Could a reasonable juror find by preponderance of evidence that this is what it purports to be? So it doesn't have to be perfect. It doesn't have to be conclusive. It has to be more likely than not. Could a reasonable juror find that? So when you're looking in Maryland to try to go off that, it's very important for you to consider these cases that have already been decided in a slightly different context by the Maryland Supreme Court, but still continue to apply. So as you're looking at the rules themselves, then you want to also analyze these cases to determine how they might cause the court to want to come out one way or the other. All right. There are two proposed rules that the Federal Rules Advisory Committee have been looking at. The first one is Rule 707, and Professor Grossman has it up here now. This is a curious rule, but we like it, not just because it's curious, but because we think it does something important. And it's what makes the rule curious is it basically says, well, if you're going to authenticate artificial intelligence evidence, and you're not going to call a witness, a live witness, to get on the stand and to cover the topics that we've been talking about. And to pause right here, you might say, well, how could that happen? And the answer is, take a look at Rule 902.13 and 902.14, 5-902.13, 5-902.14, which allow you to be able to do that through a certificate. So if you're not going to call a live witness to testify about how this evidence is authentic and could be considered, but if you were to do that, the person who you would call, i.e. the person who's going to give you that certificate, would be the kind of person subject to Evidence Rule 702 as an expert, scientific, technical, specialized information, then you've got to establish, even without a live witness, the underlying requirements of Federal Rule 702. Now, let me stop you right here. The Maryland courts have adopted Rochkin. That says Daubert. But the text of Maryland Rule 5702 is different than Rule 702 under the federal rules. Because in the federal rules in 2020, they modified it to have specific factors that the judge had to say that the proponent had established, and this most recent change by a preponderance of evidence, most likely than not, where the judge shouldn't let it in. And that is qualifications, factual sufficiency, methods and principles reliable and reliably applied to the fact of the case. So this rule, if it is adopted, would do what Professor Grossman and I think is helpful, which is to borrow from Rule 702 and its factors. But just keep in mind that in Maryland, the text of Rule 702 is different from the text of Federal Rule 702. However, since Rochkin applies to scientific, technical, and specialized information, and since the Rochkin standard talks about error rate and reliable methodology reliably applied, an argument could be made that under the common law, again, the Supreme Court of Maryland, that the same approach should be done. And basically what this rule would do is it would say, look, if you're going to offer artificial intelligence evidence and you're not going to call a live witness, if the person who you would use to authenticate it through certificate or otherwise would be bound by the rules of 702, then you've got to show, and you can see the slide has the 4 requirements of Rule 702. The rule then goes on to say ordinarily this is going to require an expert, but there are circumstances where an expert might not be required, and we don't want to foreclose that. And notice proposed rule subparagraph 3, very important. This is the most recent change to it, the versions that we initially saw coming out, and I think that Professor Grossman and I think it's a good thing. It's going to require that notice. Remember when we were giving you the 5 tips about how you approach this? Notice is key. Because what it's going to do is, like that Maryland rule that we cited that's been around for over 20 years, we want the court and the parties to know, okay, this evidence is going to pop up in this case, so we got to put our thinking cap on and the right way to deal with it, and have notice, have discovery, have objections early on, and let the court rule. And then the final slide on this rule would talk about judicial notice. This doesn't preclude judicial notice. And eventually some of these systems that become sort of legacy systems are going to be judicially noted. But right now we haven't gotten that far. And then a definition. The next one is a proposed rule that the advisory committee is looking at. And this would be the unacknowledged artificial intelligence rule, or what we have called the deepfake rule. And what we want to avoid is this. For people who are experienced trial lawyers, objections come sort of in different flavors. So Professor Grossman has complained to the police that to her shock and dismay, her erstwhile friend and co-author of 20 plus years, Paul Grimm, left this threatening, intimidating, and extortionate voicemail message on her phone that says if she does not disavow certain papers that she has written, then she'll never see her pet chihuahua again. I'll make sure that it disappears. And she says, I know his voice, that's him. And I am objecting to that, saying, well, wait a minute, I would never do that. First of all, I've worked with Professor Grossman for over 20 years. We're not only colleagues, but we're friends. This would never happen. I didn't even know she had a chihuahua. And that would never be me. What does it take to raise a sufficient objection on the basis of a deep fake or fabricated evidence? Well, one objection might be she gets on the stand and she says, it pains me to say this, but I've known him, I know his voice, this is him. And the prosecutor says, I'm now going to move to introduce Exhibit 1, the voicemail message by Grimm. And my lawyer stands up and says, objection. The judge says, well, what's the basis for your objection? Insufficient foundation. That's a completely conclusory objection. It doesn't say why the foundation is insufficient, what it should be, any error. And in most instances, the judge is going to say, if they think that it hasn't been done enough, they'll say, could you add some additional foundation? Or they're just going to say overrule. The second objection is the liar's dividend objection that Professor Grossman talked about. I describe this as the lions and tigers and bears objection. So Professor Grossman's on the stand. She says, it pains me to say this, but this is his voice. I know it well. Her lawyer, the prosecutor, says, I'm going to introduce Exhibit 1, the voicemail. And my lawyer jumps up and says, Your Honor, you can't even open a newspaper today without reading about deepfakes. And anybody can have access to these computer simulations. Grimm has been out there. There's YouTube videos of him talking about this stuff. He's got a podcast. There's all this media out there. It would take nothing to put 90 seconds of his voice and his image into this software and type in what he says, and it comes up with a fabrication. How do we know that wasn't done? This is terrible stuff. It's very prejudicial. Now notice there's no facts to support any of that. It's just an argument on speculation and conclusory allegations. That should not be sufficient. Instead, and this relates to an example of a rule that we proposed initially that the committees looked at and then ultimately came up with the language that you see here. What is the correct showing by the objecting party that will sufficiently raise the issue about whether this is a deepfake or not? And if so, how should the judge act with respect to it? And that's what this potential rule says. The first thing is that the proponent has full latitude to authenticate it in the first instance, however they want to do it. Then, if my lawyer wants to object, then I've got to come forward with evidence, not conclusion, not lions and tigers and bears, not conclusory allegations, but evidence sufficient for a reasonable jury to find that it could potentially have, more likely than not, have been fabricated. And then what happens is that the proponent, the prosecutor in this hypothetical, could come back and add, say, corroborating information or other evidence, or might say, well, I think I did a sufficient job before. And then the showing is, if the opponent makes a showing, the item of evidence is admissible only if the proponent demonstrates to the court that it more likely than not is authentic. This is a slightly different standard than what Professor Grossman and I initially thought would have been the best one. But what's good about this rule and why we think this is certainly much better than what is the existing circumstances where we don't have a rule dealing with deep fakes, is that the judge is making that call. This is going to avoid that 104B issue where the judge says, gosh, it could be yes, it could be no. Grossman knows his voice, he says yes, but Grimm has got this evidence that says that he was on a plane and he couldn't have done it because there was no Wi-Fi and he's got a corroborating witness. It could go either way. I guess I should let the jury hear it. Well, that's the problem that we have, and we don't want that. We want the judge to be the one to make the call about whether it is unfairly prejudicial. What would make it unfairly prejudicial if the proponent, at the end of the day, after my evidence to challenge it, if the judge determines more likely than not that it's authentic? Because then we have the judge making that, not just sending it to the jury and say we'll have to let them decide. Notice that in the final slide there, that this rule also has a notice provision. And I think it's fair to say that Professor Grossman and I hope that the decision this fall is to actually put this out for public comment. I mean, just because you put it out for public comment doesn't mean it's going to get across the finish line, but it's a good starting point, particularly since it's going to take another year or two even to get through the public comment. And we think that the cases that we've cited showing that this evidence is coming up are only going to continue to multiply. mostly coming from the states, but starting to creep into the federal system. And given the nature of this evidence and the impact that it can have, which is unique, that it's better to have a conversation about this now, even if there's not overwhelming evidence that we've got a crisis that we've got to deal with, because by then it would take 3 years to deal with the crisis, and we want to avoid that. So this notice provision is involved in that as well, that the party claiming it's fabricated has to give notice, and more than notice, then say, and here's my evidence. So we think that this is a helpful rule. Stay tuned. As Professor Grossman said, we think that this has been sort of put on hold until the fall, October meeting of the Rules Committee. There will be a symposium then that will be talking about it. We're hoping that we might be able to provide some input there. But stay tuned, because this may be something that you can see coming up. I want to end with one other rule that the audience should be aware of that we haven't covered so far. There is a new evidence rule, relatively new in the federal system. It's been around for about a year or 2 years. It's Evidence Rule 107. There is as yet no Maryland equivalent. It deals with illustrative aids. And what it says is that illustrative aids, which can be anything as basic as a hand drawing on butcher paper to as sophisticated as those virtual reality AI used in that bar case, the stand your ground case that Professor Grossman talked about, and that these can be used for either of two purposes, either to illustrate evidence that has already been admitted and may be considered by the jury, or argument by counsel, unless the judge says that the probative value is substantially outweighed by the danger of unfair prejudice. So that's the 403 standard that says that these illustrative aids should come in unless the probative value is substantially outweighed by the danger of unfair prejudice. The second part of Rule 107 says that it's not admissible for the jury to consider when they deliberate unless all parties consent or the judge finds that there's good cause to let the jury see it, and then gives a limiting instruction to the jury. Now, this is kind of a sleeper rule, because there's nothing better than that, the stand your ground case that Professor Grossman talked about, to show that you're not going to offer that visual, the alternative reality, as if it was a scene that actually was being recorded when the altercation in the bar took place, but rather to help the jury understand the testimony of the defendant that he felt his life was threatened and he had to use this weapon to protect himself. And all the background that we've talked about, the impact that that kind of stuff can have on the way the jury looks at it, this would be an illustrative aid. I will tell you that in May, last month, the Maryland Standing Committee on Rules of Practice and Procedure considered whether or not Maryland should adopt this same rule. And it has not, obviously the committee's got to propose it if it feels that's appropriate, and then it's got to be considered by the Supreme Court. But it may be that this rule will pop in, and you're going to start seeing the utility of some of these generative AI tools to come up with illustrative tools that will demonstrate what one party says is what their argument is, that their evidence allows to be able to understand how the case developed. So this has real potential down the line, so stay tuned for that here in our own state. And with that, I will stop. And I think that on behalf of Professor Grossman and myself, we hope this is of some value to you. It's been a real pleasure and privilege for us to hear and to be here with you and spend some time on these topics.
Thank you very much.
All right, I'm going to stop the recording.